Alright, Federal Motor Carrier Safety Administration, Title 49 CFR Chapter 3, Part 386 Rules of Practice, Form, and Federal Motor Carrier Safety Administration Proceedings. Subpart A, Scope of the Rules, Definition, General Provisions, Scope of the Rules, and Part of the Definition, Separation Functions, Appearance of the Rights of Parties, Forms of Filing, Extension of the Time, Services, Filing, Documentation, Computation of the Time. Subpart commencing with the proceeding and pleadings, comments met with the proceedings, complaint with petition, review the request for the hearing and provide qualification proceedings, reply or reserve the actions and replies on the notice of the claims, intervention and payment of the claims. Subpart C, settlement agreements and their contents. Subpart D, general rules and hearing enforcement proceedings under this part of the 395. Official notice, motions to dismiss. The motion is more definite statement. Motion final agency order, discovery scope, the discovery protective order, supplementation of response, stipulation regarding discovery interrogatories to the parties, production of documents and other evidence, entry upon landing and inspection, other purpose of the physical and mental examination, request of admission and motion of a compelling discovery, disposition and upon disposition at hearings, medical records and physician reports, formal written of evidence. Amendment of the withdrawal of the pleadings, appeal for the interlocutory rulings, subpoenas, witness fees, the administrative law judge, pre-hearing conferences, hearings, providing findings of the facts and conclusion of law, burden of proof. Subpart E, decision review, administrative law judge, decision on review, reconsideration, failure to comply with the final order, motion, rehearing, modifications, judicial review. Subpart F, injunction, imminent hazard. Injunction, imminent hazard, operation, out of the record of the consolidation, proceedings, reincarnated carriers. Subpart G, penalties, general, civil penalty violation, non-notice and order sanction for the failure to pay civil penalties, abide with the payment plan, operation, interstate, commercial, prohibited sanction, failure to pay civil penalties, and abide payment plan, suspension of revocation of registration. Alright, Federal Motor Carrier Safety Administration. The scope A, scope of the rules, the definition, general vision. Scope of the rules in this part of the scope provided by the paragraph C of the section, the rule of the part of the governor perceived that before the assistant administrator who acts with the chief of the safety officer, Federal Motor Carrier Safety Administration, under applicable provisions of Federal Motor Carrier Safety and Regulation, Title 49 CFR Part 350-399, including commercial regulation, Title 49 CFR Parts 360-379, hazard material regulation, Title 49 CFR 171 and 180. The purpose of the proceeding with enable the assistant administrator determine whether the motor carrier intermodule equipment provided is defined with 390F, 395 of this chapter, the property broken freight railroad agent that employs any other person subject to the jurisdiction of Federal Motor Carrier Safety Administration had failed to comply with the provision requirements for the application statute of the corresponding regulations to issue the appropriate with the order with the compliance with the statute with regulation and the civil penalty of both and such violations are found. C1, rules of 386-12A with the governing file with the complaint with a substantial violation, handling of the complaint with the appropriate division administrative of the rules, and 386-12B with the governing of the file with the driver, the handling of the appropriate division administrative of the complaint with the harassment and violation 390-36, subchapter the rules of 386-12C with the governing of the filing driver, the handling of the appropriate division administrative of the complaint with the cohesion of the violation 396 of the subchapter. 386.2 definition of abatement means for the discontinuing the regulatory violations by refraining from taking actions identified with the notice of the correct noncompliance. Administration means the Federal Motor Carrier Safety Administration, administrative injunction means the process of the proceedings to resolve the contest of the claim for the conformity with the Administrative Procedure Act of the Title 5 U.S. Standard Code 554, 558, administrative law judge means the administrative law judge appointed for the pursuant for the provision of Title 5 U.S. Standard Code 3105, agency, the Federal Motor Carrier Safety Administration Agency Council means that the attorney prosecute the civil penalty matter of the behalf of the field administrator, associate administrator of the associate administrator, Federal Motor Carrier Safety Administrator, of the assistant administrator, of the chief safety officer of the agency, pursuant to Title 49 U.S. Standard Code 113E, the decision of the assistant administrator and motor carrier broke forward hazard material proceedings under this part. Administrative final broker means the person who can compensation arrange for the offers for the arrange for the transportation property by authorized motor carrier, the motor carrier person who are employed to the bona fide agent with the carrier that is not broker within meaning of the section with arrange for the offers for the arrangement of the transportation shipment which is authorized to transport, which has accepted legally bound itself to transport. Civil forfeiture penalty proceedings of the proceeding collect for the civil penalty violation under the Commercial Motor Vehicle Safety Act of 1986, with the Hazard Materials Transportation Act of 1975, the amended, and the Motor Carrier Safety Act of 1984, the U.S. Chapter 311, Subchapter 3, Section 18 of the Bus Regulatory Reform Act of 1982, Section 30 of the Motor Carrier Act of 1980, and the Interstate Commerce Commission Termination Act of 1995. Civil penalty proceedings means the protecting the collective civil penalty violation regulation statute within the jurisdiction of Federal Motor Carrier Safety Administration. The claimant means that the representative of the Federal Motor Carrier Safety Administration authorized to make the claims. The commercial regulations mean that the statute regulations apply to the person providing the arranging the transportation compensation subject to the Secretary jurisdiction under the Title 49 U.S. Code Chapter 135. Chapters are codified with the Part B, Subtitle 4 with the Title 49 U.S. Code 13101 through 149913, the federal regulations issued for the Federal Motor Carrier Safety Administration and the procedures predecessors under the authority provided in Title 49 U.S. Code 13301 predecessor statute. Decision maker means the assistant administrator of the Federal Motor Carrier Safety Administration acting in capacity of the decision maker, any of the person assistant administrator that has delegated his or her civil penalty proceeding as an subject of the agency decision official authorized to issue financial decision order in an agency civil penalty proceeding. The default means the omission of failure to provide legal duty within the time specified with the action, failure to reply with the notice of the claim with the time of the required failure to submit the reply with accordance with the requirements of this part of the default may result in court issuing with the final agency order with an additional penalty against the default party. The department uses means the U.S. Department of Transportation docket of the operation, either the Department of the Transportation docket with the management system, which is in the Century Repository, original copies of all of the documents filed before the agency decision makers. Federal qualification proceedings mean that the pronounced proceeding commenced under Title 49 CFR 391 147. The issue with the bad letter of the disqualification. Federal Motor Carrier Safety Commercial Registration Regulations. Federal Motor Carrier Commercial Registration Regulations means statute regulations applying with a person provided with arranging transportation for compensation subject to the Secretary jurisdiction under Title 49 U.S. Standard Code Chapter 135 statutes codified in Part P, Subtitle 4, Title 49 U.S. Standard Code 1301 through 14913. The registry regulations include those issued by the Federal Motor Carrier Safety Administration with the predecessor under the authority under Title 49 U.S. Standard Code 13301 or predecessor statute. Field Administrator means the head of the Federal Motor Carrier Safety Administration service member who have the delegated authority to initiate the compliance with enforcement action on behalf of the Federal Motor Carrier Safety Administration. Final agency order means the final action of the Federal Motor Carrier Safety Administration issued pursuant to the power of the appropriate field administrator with the default judgments under 386.14, the assistant administrator for the settlement agreement to become the final agency order pursuant to 386.22, decisions of the administrative law judge, which become final agency order pursuant to 386.61, binding arbitration awards the person who failed to perform the petitions directed with the final agency order committed the violation of the order subject to the additional with the penalty of the prescribed in subpart G of this part. Federal Motor Carrier Safety Regulations. Federal Motor Carrier Safety Regulations. Formal hearing means the evidentiary hearing of the record and the parties for the opportunity to offer the discovery to present relevant evidence, cross-examining witness. Straightforward means the person beholding itself of the general public other than an express pipeline, sleeping car with motor and water carrier to provide transportation property with the compensation of the interstate commerce for the ordinary course of the business. Perform to provide the assembly with consolidation, break bulk with the distribution, shipment, assume the responsibility of the transportation with the place for the receipt of the destination, use any of the part of the transportation of the carrier subject to the Federal Motor Carrier Safety Administration jurisdiction. Hearing officer means the neutral agency employed within the name of the assistant administrator to preside over the informal hearing. The Federal Hazard Material Regulation. Informal hearing means the hearing in which the parties have the opportunity to present relevant evidence with the neutral hearing officer who will prepare findings found the recommendation agency decision maker. The informal hearing will be not only with the transcribed record of the discovery will not be allowed, but the parties will have the opportunity to discover the case for the present testimony evidence before the hearing officer without the formality of the formal hearing. Mail means U.S. first class mail with the U.S. registered certified using of the commercial motor delivery service. The motor carrier of the means of the motor carrier of the motor private care for the motor carrier of the migrant workers of the defined in Title 49 CF United States Code 13102 3210501. Notice of claim means that the initiate the document issued with the Federal Motor Carrier Safety Administration. Serve the civil penalty alleged violation of the Federal Motor Carrier Safety Regulation has material with the Federal Motor Carrier Commercial Regulations. Notice of violation means the document alleging violation of the Federal Motor Carrier Safety Regulation has material Federal Motor Commercial Carrier regulations from which the corrective action other than payment of civil penalties recommended in person means that the individual party in his partnership, the association, cooperation, business trust, and any other organized group of individuals. Reply means a written response with notice of the claim admitting that denying the allegation contained within the notice of the claim. In addition, reply with the providing of the mechanism for determining whether the respondent seeks to pay the settle of the concept to seek binding of the arbitration of the claim. Fee 386.14 contesting the allegations of the reply must also set forth all the knowing affirmations, defense, and factors in the mitigation of the claim. Petitioner means the party petitioning overturn the determination of the driver qualification proceeding. Respondent means the party against the relief that sought the claim is made. The Secretary means the Secretary of Transportation. Submission written written evidence without the hearing means the submission of the written evidence legal argument with the agency decision making in his or her representative in lieu of the formal and informal hearing. 386.3 for the separation of functions, civil penalty proceeding will be prosecuted agency counsel who the representative field administrative that knows the violation field administrative with the representative of the agency counsel. Agency employee include those listed in paragraph C of the section that engage in the performance of the investigative, prosecutorial functions, civil penalty proceeding, but not in the case of the factual related case of the discuss, the communicate the facts and an issue that involve the agency, the decision maker, administrative law judge, hearing, and officer for the other listed in paragraph G of the section, except for the counsel, the witness, the public proceeding, the prohibiting, all this include the staff and those covered and with this section, deputy chief of the counsel, assistant chief of the counsel, and enforcement litigation attorneys in the enforcement litigation division serve the enforcement action counsel in the prosecution all cases brought under this part. Chief of counsel, the special counsel, the chief of counsel, and the attorney serving the injunction with the counter counsel divided by the agency decision maker regarding all cases brought under this part. Nothing in this part shall preclude any agency decision making anyone advising the agency decision makers taking the part of the determination of the launch of the investigation issue of the complaint. Similar preliminary decision. 386.4 Appearance of the rights of the party. If the party may appear within person of the counsel of the representative is the party elected in proceeding under the subpart. Person representing the party must file the notice of the appearance of the proceeding with the manner of the provided with the 386.7 of the subpart of the notice of the appearance must lift the name of the address, the telephone number, the facsimile, the number of the person designated, the representative of the party with the copy of the notice of the appearance must serve on each of the party with the manner provided with 386.6. The subpart of the notice of the appearance must file with the servant before the representative that can participate in the proceeding with the in the attorney of the representative of the contact with the information must be served with and filed with according to 386.6 and 386.7 in a timely manner. A separate notice of the appearance must be filed with the representative that each case of the blanket appearances on the behalf of the party will not be accepted. 386.5 of the forms filing extension for the time of the form. Each of the document must be the typewritten, legally handwritten content of the unless otherwise specified. Part G of the document must contain a short, plain statement of the facts of the person gave the rest of the brief statement of the action with the request of the document. Except as prior order, all contents will be made with the be available link. The extent of the notice of the claim of the reply motion, briefs of the other filings may not exceed 20 pages except the permitted order following a motion to exceed 1 page, limiting the based upon the good cause shown, exhibit the attachments in support of the relevant failings of the not include the page limit, paper and margin filing document that must be printed 8.5 or 11-inch paper of the 1-inch margin on all foot side text that include the pagination of footnotes, spacing of font size for the type of the written documents. Typewritten documents will use the following line with the format, signal staging with the caption with the footnotes, the double spacing for the main format for the main text, all printed matter with the must appear with at least 12 font, including footnotes. After extension of the time, only those requests for the show of good cause will be granted. No motion for the continuous postponement of the hearing of the date with the blue file. The 15th day of the 7th, the hearing will be granted unless the accompanied with the affidavit showing the extraordinary circumstance warrant with the continuance unless directed otherwise. Agency the decision maker of the form of the matter is depending with the party of the may stipulate with a reasonable extension of the time of the filing. The stipulation of the office official docket serving copies of the all party certificate served with motions for the extension of the time must be filled within accordance with 386.7 and served within accordance with 386.6. Copy must be also preserved by the person presiding over the proceeding of at the time of the filing. 386.6 Services General. All the documents must be preserved with the party designated agent. Services of the process notes of the appearance have been filed with the specific case of the question in accordance with 386.4. Services to be made with the parties attorney with the record of the designated representative. Type of service the person may preserve the document of the personal delivery utilized in government, commercial, and even the U.S. mail, commercial mail delivery upon prior written consent with the majorities of the smile written consent. Facsimile services must specify the facsimile number where the services will be accepted. When the service is made with the facsimile, copy will also be served with any of the other method that permitted with the section. Facsimile services occur with the transmission with the complete certificate of service. Certificate with service will accompany with the document served them the proceeding under the support of the certificate must show for the day of the manner of the service signed with the person making the service list of the person serving in accordance with 386.7. Date of service. The documentation with the date with the personal delivery of the mail or mailing date shown with the certificate of the service of the date with the shown with the posting mark with no certificate. The service with the other mailing date shown with the other evidence if there is no certificate service of the postmark. Alright, valid service. The properly addressed the document and set in accordance with the subpart which was the return claim the refused and deemed to have been served in accordance with the subpart with the service may be conserved with the validated date when the time of the document was mailed and date with the personal delivery of the document was refused. The service by delivery after 5 p.m. time zone with which the recipient received delivery is deemed to have the made then on the next day, but that is not on Saturday or Sunday, legal holiday. Presumption of the service of these shall be the presumption service of the documentation served on the party of the person customarily receive this mail address a designation entry of the appearance if the entry of appearance has been filed with the behalf of the party service of the effectively upon the service of the document and the representative. 386.7. Filing of the documents. Address the method of filing. The person serving the entering of the document of the filing must personally deliver in the mail one copy of each of the document. All parties counseling their designated representative record and representative of the single and signed original one copy of each of the documents submitted with the Conservation Associated Administrative Law Judge. Hearing officer must be personally directly delivered and mailed to the Department of Transportation, Docket Operation, 1200 New Jersey Avenue, Southeast Washington, D.C. 20590. A person will serve with a copy of each of the document each party in accordance with the 386.6 of the subchapter 386.8. The computation of the time general and the computing any of the time preset of the rules and order and issue here under the time of the computation begin with the day of the following act and event of the default of the last day of the period includes unless the infant Saturday and Sunday legal the federal holiday in the case of the time period with the run of the end of the next day with the not Saturday, Sunday with the legal the federal holiday, all Saturdays and Sunday legal the federal holidays except those of the following and then the last day of the period will be computed. Date of entry and orders if the computing entity of the period of the time involved with the date of entry of any of the order, the date of the entry of the day of the order, serve the computation of the time of the delivery of the mail, the serve all of the documents and deemed effective of the time of the mailing of the documents are not deemed failed until the dock of the operations. Whenever the party has the right of the duty act of making them responsible within the prescribed period after service by mail with the date of certification, after services by mail 5 days will add to the prescribed period. So Part B, commencement of the proceeding and pleadings. 386.11, commencement of the proceedings. Driver's qualification. The proceedings are commenced by the issuance of determination by the Director Office of the Carrier Driver of the Vehicle Safety Standard and the case arising with the 39.147 chapter of the issuance of the letter of the disqualification. Such determination letters must be accompanied with the following situation of the regulation under which the action may be taken, a copy of the documentary evidence related to the conservative taken in such action. In the case of the voluminous evidence, the summary each of the such evidence of the notice of the driver of the motor carrier involved in case of the same petition review of each of the action notice of the hearing of the will be granted with the association. This administrative term of the material factual issue is in dispute. Notice the failure of petition review of the constitute a waiver of the right to contest the action, and notice the burden of proof that will be the petitioner in case of the rising of the run of 391.47 of this chapter. At any time before the close of the hearing and upon application of the party, the leader in the other determination made with the amendment of the law, the discretion of the administrative law judge upon such of the terms he or she approved. Alright, notice of violation. The agency issued the notice of violation. The means of notifying any of the persons subject to the rules of the part of the receive the information from the investigation of the audit, any of the other sort of the wherein in it may be alleged of the person that has violated provision of the Federal Motor Safety Regulation, has material regulation, Federal Motor Carrier Commercial Carrier Regulations. Notice violation serve as the informal mechanism that address the compliance with the deficiencies, alleged deficiencies not addressed in satisfaction with the agency. Formal enforcement actions been taken in accordance with the paragraph C of this section. The notice of violation is prerequisite for the issuance of the notice of claim. The notice of violation will address the following issues as appropriate: the specified allegations, the specific actions of the agency to determine the appropriate to remedy identify problems. 3 means of the notified person can inform the agency that has received the notice of violation either from the address of the alleged violation does not agree with the agency assertion of the notice of violation, any other relevant information, civil penalties, proceedings of the commenced by the issuing the notice of claim. Each of the notice of claim must be contained with the following statement of the setting forth of the facts alleged, statement of the provision of law allegedly violated with the response, and the procedure civil penalty of the notice of the maximum amount of the authorized to be claimed under statute, the time and form over the manner whereby the respondents may pay the consent test of the other seek the resolution of the claim. Alright, 2 additional information required with the paragraph C1 of the section notice of the claim with contained with the such for the other matters of the agency of the deemed appropriate for the regime of the collection of the civil penalty violation, motor carrier safety regulation under Motor Carrier Safety Act of 1984. Agencies may require the respondent to post copy of the notice of the claim in such place for the place is such for the duration of the agency may determine the appropriate aid with the enforcement of the law regulations. 386.12. Complaint of the complaint in substantial violation. Any person alleging substantial violation of any regulation under the Motor Carrier Safety Act of 1984 is occurring with it has occurred with the must with the written complaint of the Federal Motor Carrier Safety Administration stating the substance of the alleged substantial violation no later than 90 days after the event. The written complaint including the information of the below must be filed with the National Consumer Complaint Database at the or any this website or any FSMA division administrator agency refers the complaint with the division administrator with who agency believes they best be able to handle a complaint. Information or filing of the written complaint may be obtained by calling 1-800-SAFT. The substantial violation is one of the could reasonably lead to a result in serious personal injury or death. Each of the complaint must be signed by the complaint that must be contained. The name of the address for the telephone number of the person who failed filed with the name of the address and alleged violator with respect to each of the alleged violator of specific violation regulation with the complaint believed the word violated. Concise the complete statement of the facts relied on upon to substantiate each of the allegations, including the date of the alleged violation. Upon filing a complaint with a substantial violation under paragraph A1 of the section, the division administrator shall determine whether the complaint with a non-frivolous meets the requirements of the paragraph A1 of the section. If the division administrator determines the complaint with a non-frivolous meets the requirements of paragraph A1 of the division administrator, and shall investigate in the complaint with the complaint may be timely notified finding the resulting investigation. The division administrator shall note they not be required to conduct a separate investigation of the duplicates from the complaints. If the division administrator determines if the complaint with frivolous does not meet the requirements of paragraph A1, the division administrator shall dismiss the complaint when they notify the complaint when the writing of the reason for the dismissal. 3. Notwithstanding the provision of the Title 5 U.S. Standard Code 552, the division administrator shall not disclose they identify with the complaint, but unless they determine if the type of disclosure is necessary to prosecute the violation. If the disclosure becomes necessary for the division administrator, they shall take every practical means within the division administrative authority to ensure the complaint is not subject to the coercion, harassment, and intimidation, disciplinary action, discrimination, financial loss as a result of such disclosure. Complaint and harassment derived alleging violation of the 390, 339, 36B1 subchapter harassment must file the written complaint with the Federal Motor Carrier Safety Administration, stating the substance of alleged harassment with the motor carrier no later than 90 days after the event. The written complaint will include the information described below, but must be filed with the National Consumer Complaint Database or the Fmcsa administrator with the state where the driver is employed by the agency may refer the complaint to another division administrator who agencies believe it is best able to handle the complaint with the information filing of the writing of the complaint may be obtained by calling 1-800-SAFT each. Complaint must be signed with the driver that must contain with the driver the name and the address of the telephone number, the name and the address of the motor carrier alleged harassing the driver, the concise, the complete statement of the false facts relied on substantiating each of the allegation of harassment, including the ELD, the other technology combination with which the non-separable ELD was used to contribute to the harassment, the date of the alleged action, however the motor carrier's action violated either 392.3 or 395. Each complaint may include any of the supporting evidence that will assist the division administrator in determining the merits of the complaint with the upon filing the complaint with a violation under paragraph B1 of this section, appropriate of the division administrative shall determine whether the complaint with the non-frivolous meets the requirements of paragraph B1 of this section. Alright, if the division administrator determines the complaint with the non-frivolous meets the requirements of the paragraph B1 of this section, the division administrator shall investigate the complaint with the complaining driver shall be timely notified of the findings of the resulting investigation. The division administrator shall not be required to conduct the separate investigation of the duplicated complaints. If the division administrator determines the complaint is frivolous, if it does not meet the requirements of the paragraph B1 of the section, the division administrator shall dismiss the complaint with notify of the complaint with the reading of the reason for the dismissal because of the prosecution, harassment, or violation of 393-60B1 of the subchapter will require the disclosure of the driver's identity. The agency shall take the variable every practical means within the authority to ensure the driver is not subject to the coercion, harassment, intimidation, disciplinary action, discrimination, financial loss as a result of the disclosure. This will include the notification Title 49 U.S. Standard Code 31105 and induce the broad employee the protection and retaliation for the filing of harassment complaint may be subject to the motor carrier of the enforcement action with the Occupation Safety, Health, and Administration. Complaint with the coercion any of the driver alleging violation of 390-60A 1 and 2, but the subchapter must file the written complaint with the Federal Motor Carrier Safety Administration state the substance of alleged coercion no later than 90 days after the event, and the written complaint with including the information described below that must be filed with the National Consumer Complaint Database for the Federal Motor Carrier Safety Administration Division Administrator of the state with the driver and is employed with the agency may refer the complaint with another division administrator who the agency believes is best able to handle the complaint information following with the written complaint may be do so with the obtained with 1-800-SAFETY. Each complaint must be made designed with the driver and must contain the driver's name, address, the telephone number, the name and the address of the person allegedly coercing the driver, the provision of the regulation of the driver alleges he or she will coerce the violate. Concise but complete statement of the facts relied upon the substantiating each allegation of the coercion, including the date of each of the alleged violation actions for the complaint with the coercion under the filing complaint with the coercion on paragraph C1 of the section of the appropriate division administrative shall determine whether the complaint is non-frivolous to meet with the requirements of paragraph C1. Alright, the division administrator determined the complaint with the non-frivolous meet with the requirements of paragraph C1 of the section. Division administrator shall investigate the complaint with the complaint of the driver shall timely notify of the finding and result of the swift investigation. The division administrator shall not be required to conduct a separate investigation with the duplicated complication complaint. If the division administrator determines the complaint is frivolous, does not meet the requirements of paragraph C1 of the section, the division administrator shall dismiss the complaint and notify the driver in writing of the reason for the dismissal of the protection complaint. For the cover of the prosecution, coercion violation 396, subchapter will require the disclosure of the driver's identity. The agency shall take every practical means with the authority to ensure the driver is not subject to the coercion, harassment, intimidation, disciplinary action, discrimination, financial loss. As a result of the disclosure of this will include the notification in Title 49 U.S. Standard Code 31105 and include the broad employee with the protection of the retaliation filing coercion complaint may be subject to the alleged coercion to enforcement action with the Occupational Safety, Health, and Administration. Alright, 38613 petition review the request of the hearing to have a qualification proceeding within 60 days after the ship of the determination 39147 of the chapter of the letter disqualification to drive the carrier may petition the review to such action. Such petition must be submitted. Assistant administrator must contain the following identification of the word action the petition wants overturned. The copy of all the evidence upon which the petition relies on the form set out with the 38649. All legal other arguments of the petitioner wishes to make in support of his or her position request of the oral hearing. If one desires which must be set forth the material factual issue believed to be in dispute. Certification of the petition has been filed in accordance with 386.6c. Any other pertains material to failure to submit with the petition with the specified in paragraph A of the section shall constitute the waiver of the right of the petition, the review of the determination letter of the disqualification. In these cases, the determination is disqualification issued automatically becomes the final decision associated administrative authority days after the time of the submit of the reply of the review to expire unless the assistant administrator orders the otherwise. If the petition does not require the hearing, the assistant administrator may issue the final decision order based on the evidence and arguments submitted. Alright, 38614, reply. Time of the reply notice of the claim of the respondent may serve the reply with the notice of the claim of the right within 30 days of the following. Serve with the notice of the claim of the reply is to be served in accordance with 386.6 for the upon the serve with the extent of the indicated the notice of the claim. Options for the reply of the respondent must reply with the notice of the claim with the time allotted for the choosing of the following, paying with the full amount with the serve with the notice of the claim in accordance with 386.18 with the content of this part of the context of the claim, the requesting the administrator of the adjunction pursuant to the paragraph D of this section, seek with the binding of arbitration in accordance with the agency program, although the amount of the proposed penalty may be disposed of the referral of the binding of the tribute with the contingency upon admission and liability if the violation occurred. Failure to answer the notice of the claim or respondent failure to the answer for the notice of the claim in accordance with the paragraph A may resolve the issue with the notice of the DT default with the final agency order of the default appeal administrator with the notice of the default with the final agency order will declare respond with the default further to declare the notice of the claim and include the civil penalty proposed with the notice of the claim in the final agency order proceeding the final agency order with effect of 5 days following service of the notice of the default with the final agency order of the default constitutes the admission of all the facts alleged in the notice of the claim of the waiver of the respondent opportunity to concept of the claim with the default with a review of the assistant administrator in accordance with the 386.64b with the final agency order to be vacated but with the respondent demonstrated the executable neglect meritorious defense of the due diligence they seeking to relieve the failure to pay the civil penalty the directive of the federal agency order with the constitute violation of that order of the subjecting respondent to an additional penalty prescribed in subpart G of this part. Alright, D. Request of the administrative adjunction of the respondent may contest the claim of the request of the administrative adjunction pursuant to paragraph B2 of the section of administrative adjunction of the process of the resolve of the contest of the claim of the assistant administrative law judge the hearing officer of the owens of the administrative adjunction opposition elected with the binding on the OJ respondent. Contents in addition of the general requirements of this section reply must be written within stating the grounds contesting the claim of the must be raised in the affirmative defense of the respondent intended to serve the specification of the reply. Move to admit to deny each of the special relief state with the number of allegation violation of the claim statement of the person without the sufficient knowledge of the information to admit the denial will have the effect of denial. Any allegation of the claim did not specifically deny with the reply the deemed admitted may generally a denial of the claim is insufficient may resolve the default being entered into the agency decision maker upon the by which the federal field administrator must include all the known information affirmated defenses including those relating to jurisdictional limitation procedures must state with one of the following options the respondent seeks to submit written evidence without hearing and being informal hearing, a formal hearing, or C2 reserved. Alright, 38.6.15, reserved 38.16, action for the reply, the notice, to notice of the claim, request of the submit of the written evidence without hearing, without responding, elected to submit the written evidence in accordance with 38.6.14D1.3a, agency counsel must serve with all the written evidence of the argument with the support of the notice of the claim no later than 60 days following the serve of the respondent and reply with the written evidence of the argument must be served on the assistant administrator in accordance with 386.6, 386.7, the submission must include the pleadings and notice of the other filings within case the date. The respondent will no later than 45 days serve of the agency counsel written evidence for the argument serve within written evidence for the argument and assistant administrator with accordance with 386.6 and 386.7. Agency counsel may file with the written with the respondent submission. Each of the substance must be filed within 20 days of the serve of the respondent submissions. All written evidence submitted with the parties must conform to the required within 386.49. Follow submission evidence of the argument and the outline within section of the assistant administrator may issue the final agency order with the order based on the evidence of the argument submitted may issue any other order may master with the adjustment educated with the matter. Requesting with a hearing if the request of the formal and informal hearing has been filed with the assistant administrator to determine whether there is an issue with the dispute with the material fact within this matter and so for the matter set forth in the hearing in accordance with the respondent reply with if the determination that does not exist with the dispute with the material fact is issue with the matter assistant administrator may issue the decision based on the written record of the may request the submission of further evidence or argument, and if the respondent requests a formal informal hearing as a reply with the field administrator must serve upon the assistant administrator of the respondent the notice of the consent of the objection on the basis of the request for the 60 days service of the respondent reply with the failure to serve the objection will take time allotted may resolve the referral of the matter of hearing. Alright, 3. Request of the formal hearing. The following filing with the objection on the basis of the field administrator must serve the motion of the field agency order with the pursuant 386 unless otherwise ordered by the assistant administrator of the must be set for the region of the field administrator of the any judgment with as a matter of law of the respondent must within 45 days serve the motion the final agency order submit the service as a response. Field administrative motion after review of the record with the assistant administrator will either set up the matter of the hearing of the referral of the officer of the hearing and issue the final agency or based on the submission. 4. Request for the informal hearing. If the field administrator objects for the basis of the request for the informal hearing, he or she must serve the objection of the copy with the notice of the claim with the copy of the respondent, reply with the respondent, assistant administrator of the pursuant paragraph B2, section based on the notice of the claim and the replying with the objection based of the assistant administrator will issue the order granting and the denying with the request for the informal hearing. Informal hearing granted with the request for the informal hearing is granted with the assistant administrator. Associate assistant administrator of the hearing officer will be assigned to hear the matter of the will set forth the date, location of their hearing, and no further motion of the entertainment with the notice discovery will be allowed at hearing that all parties may be presented. Even if the written oral hearing officers, following with their hearing officers, will issue the report assistance administrator to contain the finding of the facts remaining of the disposition matter. The report will serve as the sole record of the proceedings. The assistant administrator may issue the final agency order adopting the report, issue of other such orders as he or she may deem an appropriate matter particles in formal hearing. Respondent waive the right to the formal hearing. The informal hearing denied. If the request for the informal hearing is denied, the field administrator must serve the motion for the field final agency order with pursuant to 386 unless otherwise directed with the assistant administrator of the motion set forth in the reach of the field administrator that he's entitled to judgment as a matter of the law of the respondent must within 45 days serve the motion of the file agency is omitted to serve the respondent with the field administrator motion. At reviewing the record, the assistant administrator will settle the matter of the formal hearing. The referral to the officer for the hearing will issue the final agency order based on the submissions. Nothing in this section shall limit the assistant administrator with the authority to refer any matter of the formal hearing, even the instance where the responding seeks only with the informal hearing. Alright, 38617, intervention. After the matter is called for the hearing before the day of the set of the hearing of the beginning with any person with the position with the interview with the position is to be served with the administrative law judge of the position must set forth the reason with the position alleged that he or she is entitled to intervene. Position must be served on all parties in accordance with 38631. Any part of the file with the response within 10 days of the service of the position, the administrative law judge shall be detained. Alright. The administrative law judge shall determine whether the permit is denied the petition. The petition will be allowed the administrative law judge to determine if the final decision could directly and adversely affect the position and class, or he or she represented the petitioner may contribute materially to this position proceeding with his or her interest not adequately represented by existing parties once submitted a petitioner as a party for the purpose of all subsequent proceedings. Alright, 38618, payment of the claim. The payment of the full amount of the claim may be paid at any time of the issuing of the final agency order with the constitutive admission of the liability of the respondent of all the facts alleged, notice of the claim, unless the parties agree with the writing and the payment of the shall be treated with the admission after the issuance of the final agency order claim with the subject of the interest and penalties and administrative charges within accordance with 31 United States Code 3717, Title 49 CFR Part 8931, Title Code Federal Regulation 9019. If the respondent elects to pay with the full amount with his respondent with no notice of the claim of the payment must be served upon the field administrator at the service of the sign of the designated with the notice of the claim within 30 days of the following. The service of the notice of the claim not written in reply with the necessary respondent elects the payment. Not writing in the reply with the necessary respondent elects the payment. That opening option. Failure to serve the full payment in the 30 days service notice of the claim with the option has been shown for the constitutive of the default with the main result of the notice of the claim, including the civil penalty assessed for the notice of the claim becoming final agency order. In the proceeding pursuant to 386.14c, unless otherwise agreed in writing of the parties of the payment of the full amount with the respondent with the notice of the claim and constitute an admission of the liability of the respondent, all the facts of the alleged notice claim of the payment of the waive of the respondent, opportunity further consent of the claim, and the will resolve the notice of the claim becoming the final agency order. Alright, so Part C, settlement agreements. And I'm going to cut the tape there.